Welcome back. You're watching The Firm. Now, international arbitration clauses are ubiquitous in most contracts, and research shows that the International Chamber of Commerce, or the ICC, is the most popular arbitration center. So for those of you who go by the ICC, here's some good news. It has made several unique changes to its arbitration rules. For instance, allowing consolidation of claims or the provision of an emergency arbitrator. Now, this not only helps the ICC ahead of others, such as the Singapore International Arbitration Center or the London Court of International Arbitration, it, more importantly, cuts down the time and cost of dispute resolution. Paswini Upadhyay gets you the details.
A 2010 survey says that 70% of companies include an alternative dispute resolution mechanism in their contract to avoid court delays. Now, this alternative dispute resolution or arbitration is often governed by international rules to provide neutrality, especially in contracts with foreign parties. And of the half a dozen international arbitration centers, the ICC or the International Chamber of Commerce is the most commonly used one.
To keep pace with the growing needs of business, the ICC has made several unique changes in its arbitration rules that will become effective next year.
Generally, I guess arbitration uses, the main criticism are that it's quite costly, it takes a while, lawyers are, taking control of the process, and it doesn't really address the business needs of the users. It doesn't hasn't yet moved with its time, and really what the new rules are trying to do now is address the concerns of the users.
The three most important changes that the ICC has made are in tackling jurisdictional challenges, emergency arbitrator procedure, and most importantly, multi-party and multi-contract disputes. On the jurisdictional challenge front, the changes are designed to save time. Under the current rule, if a party to the contract questions the ICC's jurisdiction in spite of the contract specifying it as the arbitrator, the challenge proceeds in 4 steps: claimant's request for arbitration, respondent's answer, ICC court hearing, and appointment of tribunal. In the new rule, the ICC has done away with step 3. Now, jurisdictional challenges will be heard by the tribunal directly.
It was referred to ICC court, it would have delayed the process, whereas by giving these powers to the arbitral tribunal itself, it would in that sense expedite the process. And the examples why this was needed was that one of the party could always challenge the jurisdiction of ICC to administer the particular dispute in order to delay the process of resolving the dispute.
Between 2006 and 2010, about a third of cases were challenged, but only 4% of those were actually successful with jurisdiction challenge. So you can see there's lots of unmeritorious challenges out there, and there was a lot of a waste of time. So the new rules, the big change is now the tribunal can decide these jurisdiction challenges, except if the ICC Secretariat decides otherwise. In rare cases, they will do. And that's really the main change, and that will speed up the process, and it's also consistent with the general principle of competence, which is that the tribunal can decide of its own jurisdiction.
The second business need that the ICC's new rules address is for situations where a party may require urgent relief. Under the current rule, if a party cannot wait for the approximately 2 to 3 months it takes to set up an arbitrary tribunal, it has to approach a national court for relief. The new rule will allow parties to request for an emergency arbitrator who will be appointed by the ICC court president within 2 days of the request. The emergency arbitrator has 15 days to deliver a decision.
There are, in these fast-growing world, emergency situations, and the examples which I could give you is transfer of shares in case there is a shareholders agreement or a joint venture agreement, or asset stripping. In order to prevent asset stripping or the transfer of shares, it's extremely necessary to have these emergency orders or emergency award to be included in the rules, so that the party's interests are protected, rather than at a later date then make a claim for damages.
By bringing in this clause, what has happened is, you know, there is a risk when you go to the court. There is a court who can throw you out immediately, say, hey guys, this is an arbitration matter is concerned in this contract. It is governed by an arbitration provision, so you rush to the arbitration court only and get those benefits of interim injunctions out over there. Now with this sort of clauses coming in the arbitration rules itself, what will happen is there will be not only saving of cost and the time, but the dependency on those external courts or the judicial courts in India would get perhaps reduced.
But most importantly, the ICC's new rules deal with the growing complexity of business disputes by making provision for multi-party and multi-contract disputes. Companies will now be able to resolve disputes arising from multiple contracts with one party in one hearing. Also, the ICC courts are now empowered to consolidate claims. For instance, if there is an overlap between two claims being heard before the court at the same time, they can be clubbed to avoid the risk of contradictory judgments.
Yes, it's a good provision. It allows a party the flexibility of bringing multi-parties into one arbitral tribunal. Let me give an example. I have given a contract to EPC for or to L&T. I'm just taking a name, not for with any other purpose. And L&T has subcontracted to various other suppliers, civil contractors, and all those things. Now, if I have a dispute with L&T, and L&T, though it is responsible as a principal employer or a principal contractor on behalf of its subcontractor, I would be, as an aggrieved party, far more helpful for me to bring in those parties also into the dispute foray, so that I have a complete disclosure of what transpired between the L&T and its subcontractor, in order to come to a fair conclusion that what my grievance is valid and correct one, and let the arbitral tribunal on the basis of the whole thing decide. So this is a good part from an Indian perspective, because most of the Indian EPC contracts, the project contracts, there is multiple subcontraction.
The same applies obviously to joint ventures when you have maybe one contract but more than two parties, or also in the insurance industry where it's quite often there's also reinsurance with the risk passing on through a series of contracts. Nowadays there's so many cases of multi-party or multi-contract situations, and this is what the arbitration rules, the new ones, have tried to address.
Cheaper, faster, better. That's what at least the ICC hopes its rules will do to arbitration proceedings. But will it do wonders to dispute resolution in the Indian context is debatable, because the endemic problem here is that the disgruntled party in most cases ends up challenging the award in the court, which not only puts pressure on the judiciary, but it renders the entire arbitration process rather redundant. In Mumbai, Paismini Upadhyay.
With that, I'm going to wrap up this edition of The Song. Thanks very much for watching. We'll be back next week. Till then, do remember to stay in touch.